This story features one of the most infuriating courtroom encounters you'll ever see. A full-blown Karen who's convinced she's a legal expert, yet can't take a single step without demanding a real attorney to guide her every move. But before we dive into this wild situation, a quick shout out to our sponsor, Chapter. So many people on Medicare waste hundreds, sometimes thousands of dollars every single year, just because they end up with the wrong plan. It's not even their fault. Most are misled by sales agents chasing commissions instead of genuinely helping people. That's exactly what inspired Chapter's creation. The founders watched their own parents get trapped in that broken system and decided to fix it. When you contact Chapter, you'll talk to a real human who will personally walk you through every Medicare option available, making sure you choose what truly fits your needs. And the best part? The call costs absolutely nothing. With seniors saving an average of over $1,000 annually, and the holiday season right around the corner, there's never been a better time to keep some cash in your pocket. Call the number on your screen or hit the link in the description to see how much you could save, or just to make sure you're already on the best plan. Huge thanks to Chapter for sponsoring today's video. Now let's get into this insane courtroom drama.
Benedetto, good afternoon. You can go ahead and come forward, please. And Ms. Benedetto, I'm going to go ahead and have you have a seat right there. Please make sure the microphone is in front of you and the green light should be on. That's really important so that we can make sure that everything that we are discussing here today gets picked up.
Can you hear me? Yeah.
Yep, I sure can. Okay, so we are before the court for a special set 2 o'clock calendar in City of Lakewood versus Gail Ann Benedetto. 2 different cases involving Ms. Benedetto, 25L000583 and 25L004426. Both matters are before the court today for pretrial conferences. By way of procedural history, Ms. Benedetto was last before the court, let's see here, back on September 9th, 2025. At that point in time, Ms. Benedetto made a motion to the court to have her attorney of record from the Horwath law offices, and I believe, if I remember correctly, that was Ms. Arnold, although it was Ms. Capone that was present at that time with Ms. Benedetto. Ms. Benedetto made a motion to assert her constitutional right to represent herself and to proceed pro se. The court reviewed the waiver of attorney with Ms. Benedetto on the record, and the court was satisfied that Ms. Benedetto understood the potential risks that she was taking by exercising that right. Nevertheless, Ms. Benedetto maintained her request to proceed with representing herself, and the court granted her request to do so. Ms. Benedetto then, towards the end of the hearing, and that was on a regular pretrial conference calendar where a number of other matters were waiting, Ms. Benedetto made a further record that while she wanted to represent herself, she wanted to have standby counsel appointed to represent her. At that point in time, Ms. Capone, I don't know what her terminology was, but she essentially chose not to make a record, is my recollection. I could be wrong, but I believe that's accurate. Mr. Graham put the court on notice that the prosecution may very well object to, I believe, what he was concerned might constitute hybrid representation under Washington law. And Ms. Benedetto, we set the matter over to today so that I can ask Ms. Arnold and Ms. Capone's supervisor, Angela Horwath, who is the lead attorney at that firm, to be present because they were previously your attorney of record and would be the court's default choice for standby counsel if the court appoints standby counsel. And I also wanted to give Mr. Graham an opportunity to further elaborate on any concerns he had as the prosecutor. Again, the reason I didn't do that at the last hearing were time constraints. The issue that was scheduled to be addressed by the court today was a fairly limited one. I wanted to make sure that Ms. Benedetto, after having some time and opportunity to review the waiver of attorney, was still wanting to proceed pro se and represent herself, as she previously indicated. If the answer to that question is yes, then I wanted to next ask her whether or not she is continuing to request that standby counsel be appointed. And then at that point, if she is indicating that she is, I want to give Mr. Graham and Ms. Horwath an opportunity to weigh in as well. So first things first, Ms. Benedetto, good afternoon.
Good afternoon, Your Honor.
So Ms. Benedetto, at our last hearing, we started off kind of rocky, but by the end of the hearing, I think we were doing pretty well. I'm going to remind you that I'm going to do everything I can not to interrupt you, and I'm going to ask that you extend the same courtesy to the court as well as the attorneys, okay?
Yes, sir.
I'm also going to remind you that everything is being recorded today, so this is all on the record, if you will. So, Ms. Benedetto, your true name is Gail Ann Benedetto, correct?
Yes.
Okay, and Ms. Benedetto, you had previously indicated to the court you wanted to represent yourself. Have you had any change of heart, or is that still how you would like to proceed?
Let's pause right here, because this is the first moment the judge asks if she still intends to represent herself. And what follows is a masterclass in pure Karen chaos. Instead of giving a simple yes or no, she spins around the question like she's auditioning for a Broadway role, turning a straightforward inquiry into a cringe-worthy performance on how not to behave in front.
I question how we can proceed because I just feel like I think the term is fatal defects in the process, such as the 48 hours to have the procedural due process, right? Which I was basically forced to push through. So I was denied the right to question the arresting officers as to their training or what exactly did Mr. Graham, under a penalty of perjury, say that he feels he has sufficient evidence beyond a reasonable doubt that I've done these things that I'm not guilty of. And in all actuality, I was the actual victim on both of those occasions. And I would ask the court to investigate the address because I'm not the first one. I know of at least another woman before me. Her name was Stephanie. I don't remember her last name, but it's a pattern, and I don't know how deep it goes. But I just want to also put the court on notice that I've already been violated by my country to the betrayal of giving your citizens that you don't have any business arresting, putting them in a tribal jail that's 98% American is not tribal. It's money laundering or whatever you guys want to call it. It's fraud, and you just push everybody through. The fact that 2 different lawyers gave me the same script both times shows that that's your process and procedure, is to habitually and continuously deprive these people of their rights. And then for Nisqually to make me leave in 46 degrees raining weather on March 20th with no shoes, nothing but a small dress. I had no wallet, no phone, no nothing. I was passed out in my Jeep, completely unconscious when the police officers arrived. They didn't witness me doing anything malicious, and I did not do anything malicious. I had no malicious intent, and you will not be able to prove that beyond a reasonable doubt. So for him to lie and say that he has it, and for you to just continuously sign off. And also, I've discovered that a police officer, when he enters the charge with his badge number, automatically signs your auto signature to the warrant, so you don't have any knowledge of the warrant. That an officer is not a judge. I mean, your whole thing is just, it's not going to hold up. And I would just move to a jury. I need my peers. I'm not going to accept fines. I'm not going to accept probation. There's no way we'll come to an agreement. I need my peers to say that you guys.
So, Ms. Benedetto,
And it's been over 90 days since the malicious intent. I didn't get my 48 hours. I had 2 public pretenders. So if you continue to work with them as your go-to you know, defenders, knowing that they're not defending, then it kind of lands on you.
Really, he's not the one facing charges. Nor is he delusional enough to believe that his so-called special status places him above the law. But let's return to our leading lady of confusion, who's still doing verbal gymnastics to dodge giving any real answer.
So, Ms. Benedetto, the issues that I just heard you describing, what you've raised is a number of issues that would be motions to dismiss this case. Hold on, I let you finish, now you let me finish, okay?
Yes, sir.
I'm not contesting that. I think you do have the right to bring whatever motions that you think are appropriate if you believe your rights were violated. My question for you at this point is, people in criminal cases in this state, in this country, bring motions to dismiss every day. The question that I need you to answer for me is whether or not you want to be assisted by, for being represented by an attorney when you bring those motions or when you seek that relief, or is that something that you want to do representing yourself? Previously, last time we were here, you said, no, Judge, I want to represent myself. So is that still the case, or are you now thinking that you want to be represented by an attorney?
I mean, if you have a competent attorney who is going to do their job like they took an affirmation to do, not Horvath or however you pronounce it, obviously her law firm has failed me twice, so I shouldn't be obligated, and I'm not obligated to accept any representation, especially from people that don't represent anybody but themselves.
So remember that, well, I shouldn't say remember. So under Washington law, if you qualify for representation at public expense, you don't get to choose your lawyer.
Right.
Now, I have appointed an attorney to represent you previously. You indicated that you did not care for that representation and that you wanted to represent yourself. The other option that you have is to hire your own attorney, and you do have a choice when you hire your own attorney who you hire to represent you, but you obviously have to have the means to hire an attorney. So I can give you time to try and hire an attorney if that's what you want to do, or you can proceed with representing yourself, or you can be represented by a court-appointed attorney, assuming you continue to qualify, but you don't get to pick that attorney, right? That attorney is picked by the court. So you may not like the choice, but that would be how that process would work. So knowing those three options, you can either hire an attorney, you can represent yourself, or you can take a lawyer that I appoint to represent you. Do you know how you want to go forward?
I have looked into different avenues, and nobody has so far wanted to, I guess, take on the case.
Wait a second. Are you actually admitting you've already talked to two separate attorneys? And both of them reached the same conclusion that you're completely detached from reality? That's surprisingly consistent, I'll give you that.
Also, I need at least 14 court days, I believe, per the rules to actually file the motions. So I wasn't even given enough time, which is why I brought them, because it said that if I didn't file it in the right amount of time, I could submit it for you to, I forget the word, but basically to go over a review in court. But I probably don't have the whole thing exactly perfect, how it's supposed to be heading wise and stuff like that. So I do need more time to prepare proper, I guess, notices or motions, although I don't feel comfortable moving anything, because I don't think that anything can move. I mean, like, literally have probably 10 or 20 violations that I can just name them, that you guys, your own rules that were not followed. So how can you, in your official capacity, knowing your oath and knowing the Constitution, right? How can you proceed just like what's Washington Constitution Section 1? What is that? Do you know that? Washington State Constitution Section 1, you know?
So, Ms. Benedetto, I think I understand the point you're making. I mean, what you said is you don't believe that the rules have been complied with and that your rights have been violated. I understand that.
Well, not just my rights, but like
Right, I get that.
RCW 1031-100, unlawful warrantless arrests. RCW 69.50.506, warrants required for drug cases. RCW 10.0.1115, accurate and correct. Oh yeah, I forgot about that. Your officers or somehow the court has misrepresented and fraudulently made up a Washington driver's license for me, which I don't have. And I beg you to show me my picture card, my paying for it, my signature for any kind of thing with the driver's license people. I don't have any contract. I'm not a commercial driver. I'm a Pennsylvania resident, as a matter of fact. I'm actually Pennsylvania Dutch.
When you say Pennsylvania Dutch, is that your code for I don't have to follow the law? Because listen, I'm from Texas, and even when I'm in Washington, I still need a valid driver's license to hit the road. It's called obeying the law, Karen. And yes, it applies to you too.
Pilgrim to the Indians, like literally, is what you did to me. Like, that is just, I mean, I just can't get over that. There's no way that that is okay.
So, Ms. Benedetto, you're wanting to...
So they lied on police reports.
Hold on, don't interrupt. Please don't interrupt me.
Sorry, I apologize.
So we're getting ahead of ourselves again. So you've identified a number of issues that you obviously feel very strongly about, and I respect that. The question that I need to figure out before we start dealing with those issues and dealing with those claims is whether or not you want to raise those issues and those arguments to the court by yourself, or you want to be represented by an attorney. So last time we were here, you said you wanted to do that yourself, but you were requesting standby counsel.
Is Ms. Horvath, is she willing to do it herself, to put herself behind the name of her company?
I have no idea. The first thing that I need to know is whether or not...
Because if she'll do it, I will give her a chance to redeem herself, and maybe I won't file bar complaints against those two attorneys of hers, if she can actually do her job.
So, Ms. Benedetto, I will tell you...
Otherwise, they all go down.
I will tell you that threatening to file bar complaints against an attorney doesn't do any good. Your attorney is somebody who is going to assist you and represent you in a case, but threatening them with bar complaints typically is not a good way to develop
them in jail over the weekend, like that person. Oh yeah, they didn't want to go. I'm sure they refused to go talk to you today. You believe that?
So, Ms. Benedetto, what I think I hear you saying is that you are not wanting to change what you represented to the court previously.
I have to represent myself.
Okay, which is that you want to represent yourself. Now,
I don't want to.
That leads me to my next question, which is whether or not you are still requesting that an attorney be appointed to be your standby counsel.
I stated what I wanted.
I'm sorry?
I think I stated what I wanted.
I'm sorry, I couldn't hear you.
I would like Ms. Horvath herself to represent me.
Okay, well, now hold on, Ms. Horvath. You understand that a standby attorney...
Is she even an attorney?
Hold on. Please don't interrupt me. Remember that a standby counsel does not represent you, right? Because what a standby counsel does is tries to give you pointers or answer questions that you may have about legal procedure or rules of evidence, but they do not represent you because you have chosen to represent yourself. They're simply there to try to help you in certain limited ways, but they do not represent you because you're representing yourself. Mm-hmm. So my question to you is, are you still requesting that standby counsel be appointed in that very limited scope where they might be able to help you understand some of the evidence rules, they might be able to help you understand some of the courtroom procedure? Is that what you are requesting?
After nearly 12 minutes of talking in circles, she finally admits she wants standby counsel. But here's the kicker. She clearly has no clue what that actually means. Standby counsel doesn't build your defense or hold your hand. They're there just to guide you through procedure and courtroom protocol. They're not about to risk their license backing one of her bizarre, reality-defying legal theories.